Board. Well, why do you supposed to have? You do? No?
I need one.
Wait, sit down.
Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, what your options are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your more serious type of offenses, whereas your misdemeanor cases are normally referred to as a petty offense. That doesn't mean that they're not serious, it just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the case. Now, as I mentioned to you earlier, we have the two categories of misdemeanors and the felonies. Now, felonies are divided into 5 categories. We'll start at the top and work our way on down to the bottom. We have the capital murder, first degree felony, second degree felony, third degree felony, and a stage jail felony. And if a person is convicted of a stage jail felony, the range of punishment is minimum 2 years to a maximum, minimum of 6 months to a maximum of 2 years, and a fine that does not exceed $10,000. Now, if a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of a first degree felony, the range of punishment is minimum 5 years to maximum 99 years to life, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishment because, as mentioned to you earlier, your case that you have in this court is a misdemeanor case. Now, misdemeanor cases are divided into 3 categories. And we'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, Class C misdemeanors are cases that start in the city court or the JP court, and they come to this court when a person is found guilty or pleads guilty of no contest in that court, and then they appeal the case. They get a whole new trial, and it comes to this court. Now, the range of punishment for Class C misdemeanor is the same in this court as it is in the JP court or the city court. And that is, with a Class C misdemeanor, the range of punishment is a fine only. And the fine cannot be above or cannot exceed $500. So a good example of a misdemeanor case is like not having your seatbelt on, speeding, or not having an expired license sticker. Those are Class C misdemeanors. Now, if a person failed to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capias pro fine. What that means is it's a warrant for your arrest for you to either pay the fine or sit the fine out in jail. And if you sit the fine out in jail, for every 1 day that you stay in jail, you will be given $100 credit toward your fine and court costs. Okay. Now, the next highest misdemeanor is Class B misdemeanor. And with the class B misdemeanor, the range of punishment is confinement in the county jail up to 180 days, or you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a class A misdemeanor. And with the class A misdemeanor, the range of punishment is minimum, well, it's a confinement in the county jail up to 365 days, which is a year. Or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is the right to have an attorney. Now, everyone that's here, you should have a clipboard or get ready to go over the clipboard. The information on that clipboard talks about your right to have an attorney. Now, the first document behind the little small or the short form should be titled Judge's Explanation of Rights to Defendants Without an Attorney. Now, we're going to go over that document and we're going to continue to refer you back to that document. Now, that document states that as a defendant in a criminal case, you have three options. Three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first one sentence paragraph below number 3 states that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date to give you time to hire an attorney. The second one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, financial questionnaire is a 3-page document and is titled Affidavit of Indigence, or maybe titled Jefferson County Affidavit of Indigence. And the document looks like this. Okay. Now, this is only for people who will be applying for a court-appointed attorney. If you're not applying for a court-appointed attorney, you don't have to worry about nothing I'm getting ready to say regarding this document. But if you are applying for a court-appointed attorney, you have to fill out the first page of this document. Okay. And then on the second page, where it says at the top, it should say defendant's oath. Okay, you would have to fill out the top portion that says defendant's oath, and then you'll go to the middle portion that's titled unsworn declaration by defendant. Okay, and once you fill that out, then you'll stop. Now let's go back to the original, the first document that I referred you to. The third paragraph is for individuals who would like to represent themselves. Now, if you represent yourself, what you're saying is that you have a right to have an attorney. However, you're going to waive or give up your right to have an attorney. You want to represent yourself. Now, if you represent yourself, you will be acting as your own attorney. And just like the attorney can talk to the prosecutors or the state or the assistant district attorneys, you'll have a right to talk to them too. But you cannot talk to the prosecutors, and we have 2 of them in court today. You cannot talk to them about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, this is only for people who will be representing themselves. Now, the written waiver is another document on their clipboard for individuals who would like to represent themselves. It's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Okay? You'd have to read and sign this document, then you'll have an opportunity to talk to one of the prosecutors about your case. Now, if you're representing yourself, you should be mindful, there's a paragraph here in block form, it states, you should be aware that there are dangers and disadvantages of self-representation. Waiving the right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of firearms, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, the last one sentence paragraph right here, and it's for individuals who would like to represent themselves, it states that if you would like to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you talk to the state and they made an offer to settle the case. For example, as I mentioned to you earlier, we have Class A and Class B misdemeanors. You have a right to either enter a plea or plead guilty. If you say you're guilty, you're saying I committed the offense that I've been charged with, or you enter a plea of no contest. If you say that, you say I'm not contesting the charges. Or if you enter a plea of not guilty, you're telling them, well, I didn't commit the offense that I've been charged with. I'm on trial. Now, you also should be aware that a person can qualify or may be eligible for one or two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation, we normally refer to as deferred probation. And what that means is that if you successfully complete that type of probation, the case will be dismissed. It will not appear on your record as a conviction. And you may qualify for what is called a non-disclosure. Non-disclosure basically means that your record will be sealed to the general public. So the general public cannot have access to the record. So for example, Mobile Oil is part of the general public. Most all the businesses are basically general public, but the government, like the police department and some of the other governmental agencies can have access, but most of the public is general public, so they cannot have access to your record. Okay, now, the other type of probation is called adjudicated probation. I first mentioned that was unadjudicated probation. Now we have adjudicated probation. With adjudicated probation, it does result in a conviction on your record, but there's something that is called judicial clemency, whereby the court, the judge that is, can set your conviction aside, which means you will no longer have a conviction. And if you no longer have a conviction, then it is not on your record. Okay? However, if you get another case later, another conviction later on, we call it a subsequent conviction. If you get a subsequent conviction, then the case that you received judicial clemency on can be brought back up, it can be resurrected, revived, and it can be used against you. Now, and if you try to get a license with CPS, Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Okay, so as I mentioned to you earlier, if you would like to represent yourself, you have an opportunity to talk to the prosecutors. And let's say you want unadjudicated probation because it wouldn't appear on the record as a conviction. And you talk to one of the prosecutors, they say, well, we're gonna offer jail time. You say, well, I don't want that. Or you say, well, you can tell the judge, well, judge, I would like to have an attorney to represent you. You can do that. All right. Now, at the bottom of this document, everybody's gonna make a choice. There's 5 lines here, okay? You're gonna make one choice. If you would like to hire your own attorney, you'll place your initials on the first line to the left, sign and date it, and then you'll stop. This is the only document you have to sign. If you've already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you would like to represent yourself, you'll place your initials on the fifth line, and then you'll sign and date it, and that's it, okay? So everyone is gonna make a choice on this here, and just a brief recap. If you're hiring an attorney, this is the only document that you have to sign and stop. You place your initials on the first line, or if you already hired an attorney, place your initials on the second line, the name of the attorney on the line to the right. If you would like to hire an attorney, you place your initials on the third line down here. You'd have to read and fill out the first page of the affidavit of indigence. And then on the second page, you sign where it says unsworn, where it says defendant's oath at the top. And then unsworn declaration by defendant, and then you'll stop. If you would like to represent yourself, then you'll place your initials on the fifth line at the bottom. And you will fill out the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial, and then you'll stop. Okay, before we go any further, does anybody have any questions? Okay. Okay,
Maybe I need a letter.
okay. You just get out an interpreter.
Right now?
Well, we can get him, she can come, well, toward the end, yeah.
Okay.
We have a translator for the thing,
Oh.
talk to you, go over all this stuff with you, okay? Same thing with you, okay? Okay, now, we're gonna give you time to fill out that paperwork. But the next thing that you need to understand is that, for those of you, well, first of all, you have a right to have a trial by jury. For the young ladies sitting, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They can listen to all of the evidence, and they'll listen to all of the evidence that's presented by the state and the defense, listen to the arguments of the state and the defense, and then they would go into the back room, this is what we call the jury room, and they would deliberate. They can find you either not guilty or guilty. You have a right to waive or give up your right to have a trial by jury as well. And if you do that, and if you still want to have a trial, you would have what is called a bench trial. A bench trial means that you have a trial by judge. The judge sits on the bench, we call it a bench trial. The judge will be the judge and the jury in the case. The judge will listen to all of the argument, all of the evidence that's presented, all of the arguments by the state and the defense, and then the judge will apply the facts of the law and decide to find you either not guilty or guilty. Now, you also have a right to talk to the prosecutor to see if y'all can work out what is called a plea bargain. What a plea bargain is, it's a way to settle your case. We just call it a plea bargain. And that simply means that with the plea bargain, you have a right to have what is called an agreed plea bargain. If you and the state come to an agreement, we call that an agreed plea bargain. Now, that comes before the judge, and the judge can do one of two things. The judge can accept it or reject that plea bargain. If the judge rejects your plea bargain, then you can withdraw or take back your plea. So, for example, if you work out an agreement with the state, say for deferred probation or whatever, and it comes before the judge says, I'm not going to follow that, I'm not going to accept that, you can say, well, judge, since you're not following the plea bargain agreement, I take my plea back. You have a right to do that. Now, if the judge does follow the plea bargain agreement, and if you would like to, if you think within your, you think to yourself, I think I've been wrongfully convicted, I like to appeal my case, then you have to get permission from the judge. And if the judge gives you permission, the case is going to leave this court and goes to the Ninth Court of Appeals, which is on the 3rd floor, where there are 4 justices up there. They will review your case, and they can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, you can appeal your case to a higher court than them. You can appeal your course to Texas Court of Criminal Appeals located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, you'd have to file what is called a pro se petition for discretionary review. What that means is pro se means you're representing yourself. You'll be petitioning them or asking them to review your case to see whether or not your appeal should be granted or whether or not you was wrongfully convicted. They can do one or two things. They can grant or deny your petition. They grant your petition, they can simply find you not guilty. Or if they deny your petition, then at that point, your conviction will stand. Now, you also have a right to waive or give up your right. You also have a right to have what is called, we can get into what is an unagreed plea bargain. What that means is, you and the state have talked, y'all can't come to an agreement, you still want to enter plead guilty, no contest, but you want the judge to decide what your punishment is. We call that an unagreed plea bargain agreement, okay? Now, the next thing you need to know is that you also have a right to have witnesses that come to court. And what witnesses are, they sit in that chair that we call the witness stand. They can testify for you, against you. If you represent yourself, you can ask them questions, or if you have an attorney, your attorney can ask them questions, or you can waive or give up that right to have witnesses that come to court. What that means is you won't be calling witnesses. Does not mean that the state will not be calling witnesses, because they will be calling witnesses in their case. Now, you also have a right, we call it the Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your case. And basically, I know a lot of times we watch television, we see television lawyers go up to a witness and the witness say, "I take the fifth." What that means is that I'm exercising my Fifth Amendment right of the United States Constitution to not say anything against myself, to incriminate myself. Okay, now you can waive or give up your Fifth Amendment right against self-incrimination. And if you do so, then you will not be, then you will be testifying in your case. Now, you also have a right, what we call discovery. You have a right to see the evidence that the state has. They just call it discovery. You have a right to see your statements, witness statements, police reports, lab reports, photos, listen to audio recordings. You have a right to see videos, see documents, or whatever type of instruments that they have. You have a right to have access to that. We just call that discovery. You can also waive or give up your right to have discovery as well. Now, everyone that's here today, you've been arrested, charges was filed on, you've been arrested, placed in jail, you're out of jail on bond, either on cash bond, surety bond, or a PR bond. Cash bond means that you pay the full amount of the bond to get out of jail. Surety bond means you pay the bonds to get out of jail. And PR or personal recognizance bond means that you was released under your own personal recognizance without having to pay the money to get out of jail. I say that to say this. Every day that you spent in jail can be used as credit towards your punishment. Now, the operative word is every day that you spend in jail. Now, let's say you were arrested at 11:58 p.m. on last night, and you booked out of jail 2 minutes later at 12:01 a.m. this morning. That's considered 2 days. You was in jail 2 minutes, but it's 2 days. And so you get credit for 2 days, okay? Now, let's say if you spent 5 days in jail, the state is offering you to serve 5 days in jail. That means you won't have to serve no more time in jail because you'll be given credit for the time that you've already served. Now, if they offer 7 days in jail, you spent 5 days in jail, we give you credit for the 5. We subtract 5 from the 7, that leaves 2. That means you're gonna have to serve 2 days. Now, every day that you spend in jail can also be used as credit towards your fine and court costs. So for every 1 day that you spend in jail, you get $100 credited towards your fine and court costs. So if you spend 5 days in jail, that means you have $500 that can be used towards your fine and court costs. So if the state is offering fine and court costs of $500, you won't have to pay anything because the 5 days that you paid in jail has already paid it off. Therefore, it will be taxed and returned. Now, if they're offering fine and court costs of $700, that means you don't have to pay $200 because you already have $500. We subtract 5 from the 7, that leaves 2. Okay, now, Jefferson County has a program for people who have not been in trouble before, you know, have no convictions. And what they will do, they will dismiss your case. And you can get it wiped off your record. Okay? The program is called pretrial diversion. Okay? In order to qualify for pretrial diversion, you have to be first time getting in trouble. You have to have an attorney to assist you to get into the program, and it cannot be an offense for unlawful carrying a weapon or resisting arrest. Now, if you're a veteran of any one of the branches of the United States military, we have a program that is called Veterans Court. We have a representative from the VA who can come to you and tell you a little bit more about the program that they have to offer. At this time, we have Ms. Decker Blevins. Would you please come forward, Ms. Blevins?
Good morning.
Good
Hello,
morning.
everybody. My name is Decker Blevins. I am the Military Veteran Peer Service Network Coordinator. So what I do is I take service members, veterans, and their families, and I connect them with any type of resource you can think of. Housing, education, benefits, anything. So when it comes to justice involved veterans, I usually intercept a veteran before they get to this point. I will contact you either while you are in jail or immediately upon release. In that event, you can reach out to me. I have flyers, I have business cards. We are essentially here to get you in contact with the representatives for the Veterans Court. So my job is to take your request as an individual veteran or service member and say, hey, what do you need? Let me know, and we will work to get you to where you need to be. So Veterans Court, as Judge Holmes mentioned, is not specifically within this courtroom, I don't believe, but we do have different representatives throughout the area that can help you. Just contact me and we'll further, research what you need and who to get you in touch with. If you have any questions or concerns, please let me know.
Okay, thank you, Ms. Blevins.
I appreciate that.
Okay, you're welcome. Now, ladies and gentlemen, we also, as I mentioned to you earlier, you have the pretrial diversion program whereby your case can be dismissed. It will not appear on your record as conviction, and you can get it expunged, which means erased, deleted from your record. Now, we also have a program in this court that is called the CSI program. CSI program stands for Community Safety Initiative. It is a program that God led me to start within the first 100 days of taking office in March of 2017. And with that program, we have partnerships with various agencies in our area. One of the agencies that we have a partnership with is Spindletop. I think the short form that's on the clipboard is from Spindletop. And basically what Spindletop would do, they have the expertise to handle any mental health needs. You do not have to be incompetent and insane. You can just suffer from maybe anxiety or depression or any other host of mental illnesses. Spindletop has the expertise to address your mental health needs. Now, we have folks from Spindletop here, and what Spindletop can do, they can do a private interview in our jury room at their facilities or by telephone, whichever is convenient for you. Also, they can do an assessment to determine what your mental health issue may be, and they can develop a treatment plan for either outpatient or inpatient treatment. Spindletop also has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. And we have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR, OSAR, which is an acronym that stands for Outreach, Screening, and Referral, Assessment and Referral. Now, both of those programs are drug and alcohol recovery programs. And what they will do a screening, an assessment, and develop a treatment plan for either outpatient and inpatient treatment. If you're unemployed, you're looking for a better job, then we have a program that is called, we have a partnership with the Golden Triangle Empowerment Center that is a partnership with Lamar University. Lamar University has a program that is called CICE. It stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, they will help you get a job in the area that you're trained in. And if you have not graduated from high school or do not have a GED, then they have a GED program which you can receive your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. It does not cost you anything but time. And I like to say in this court, we don't just give time. We take our time. And the reason why we take our time is because we believe that we're not just gonna arrest the problem, we will address the problem. We believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And therefore, I like to say that when you come to county court at law number 2, we do not just have court as usual. We have unusual court. And the reason why we have unusual court is not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, we'll make a difference in their home. If we make a difference in their home, we'll make a difference in the community. Why? Because what comes out of the home goes into the community. So if you want to get on the road to living your best life, just let us know. We can get you started in one of these programs. At this time, we have some folks from Spinotop. They're going to come and tell you a little bit more about the program that they have. They're Caitlin and Deputy Buck.
Thank you.
You know,
Good morning, everyone.
good morning.
I'm Deputy Butler with the Jefferson County Sheriff's Department. We have been assigned to assist them with whatever fashion that they need that is legal. My part in working with Spinotop is to make sure if you become a client, to make sure you make it to your doctor's appointment. You're gonna ride, we're here to assist you in that. You're gonna ride to your doctor's appointment, we're here to assist you in that. Also with me is Ms. Caitlin. She's the qualified mental health professional. She's gonna come to you and tell you more about the Spinotop program.
So at the front of your clipboards, there should have been a really small piece of paper, it's like half a sheet. On that form, it's optional to fill out. You do not have to fill it out. It is not a court document, it is a Spinotop document. And whatever you put on that paper is protected by HIPAA between just me and you. So most of the paper is pretty self-explanatory on how you fill it out. If you have depression or anxiety or PTSD, then you can check the mental health box. Or if you deal with substance use, which can be any type of drug or alcohol, you can check the substance use box as well. And the services that we offer is you can talk to doctors, get medications if you're interested. We can help you get in contact with counseling. We can help you talk to a therapist. We have support groups and support classes for substance use. And if there's a resource that you're interested in that we don't have, we can help you find that as well. If you'd like to talk to me today about getting into services or have any questions or want me to connect you to resources, you can write on your paper, please talk to me today. And when the judge is done with you, I'll come and pull you to a back room where we can talk privately. Whatever we talk about, I don't tell the judge, I don't tell the court. It's just between me and you, unless you give me permission to tell anybody else.
Okay. Thank you, Deputy Butler and Caitlin. Okay, now, ladies and gentlemen, the paperwork that you have on the clipboard, we're gonna give you a chance to fill that paperwork out. We will put the paperwork from you. And once we pick up the paperwork, we're gonna call you up before the bench. One at a time, gonna put you in 1 of 3 categories. Either you wanna hire an attorney, you wanna apply for a court-appointed attorney, or you would like to represent yourself. Now, it's gonna take, if you need any help with filling out the paperwork, we have our court personnel who's here, who is going to, including myself, will be happy to help you finish filling out the paperwork. Now, if you need to use the restroom, there are 2 restrooms that's right outside in the hall. We have the men's restroom in front of county court at number 3. We have the women's restroom on the opposite side of the hall in front of the 172nd District Court. You'll be allowed to go out into the hallway to use the restrooms. Please do not leave the courthouse. If you leave the courthouse and your name is called, and you're not here when your name is called, your bond will be forfeited. And once your bond is forfeited, a warrant will be issued for your arrest. You'll be arrested, placed in the Jefferson County Jail, and then at some point, you're gonna bond out. We're gonna have to go through this all over again. And so we're gonna try to get you in and out. As I mentioned to you earlier, we're gonna put you in 1 of 3 categories. 1, you want to hire an attorney. 2, you want to apply for a court-appointed attorney. Or 3, you want to represent yourself. Now, if you want to hire an attorney, then your case will be reset today. If you would like to apply for court-appointed attorney, if you qualify, you will be appointed a court-appointed attorney the day before you leave. If you would like to talk to one of the prosecutors, see if you can work out a plea bargain, then if you're able to work out an agreement, your case will be taken care of today. Okay, so at this time, we're going to go into recess, make sure that you conduct yourself accordingly. Okay, we're gonna give you time to fill out the paperwork, we're gonna come out, pick up the paperwork from you. Make sure you conduct yourself accordingly because we're still in court. At this time, we're in recess.
Excuse me, sir, how long is recess? I'm not
Recess.
sure, I had.
No, recess.
Today.
Yeah, listen, okay. Okay, recess, I told you, we're gonna, pick up the paperwork, we're gonna give you a chance to finish picking up the paperwork. We're gonna pick up the paperwork. We're gonna call you up to the bench one at a time. So that's why we're in recess till we can get all of that, get that done.
So I have my own attorney, just fill out this, that's it.
That's what it says.
Okay.
Okay, anybody else have any questions? No more questions? Okay. I'm gonna get an interpreter to translate it for those two. Oh, there she is. So no, just raise your hand, she's gonna come out and pick it up.
If
Give
you're
me the
complete with
translator
your paperwork,
and the gentleman
Or if you have
in the
any
back
questions,
with the black shirt. One in a red shirt and one in back, black shirt.
if you're complete, if you're done, I can take it here. If you have any questions, I can answer these questions. And judge the force like you see. Make sure you fix your pants, babe.
Jefferson County Court Law number 2 is back in session. The court is in session in cause number 25 CCCR 2146. Case is styled the state of Texas versus Cameron Wayne LeBlanc. Mr. LeBlanc, is that your full name?
Yes.
Mr. LeBlanc, would you please raise your right hand? Mr. LeBlanc, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. LeBlanc, you may put your hand down. How are you doing, Mr. LeBlanc? Now, Mr. LeBlanc, I have a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state that you have hired Attorney Giles Cole?
Yes, sir.
Now, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. And Mr. Cole, how are you doing?
I'm doing great, Judge. How about yourself?
I'm doing fine. Thanks for asking. Now, Mr. Cole, could you hand this document that's titled Standard Bond Conditions in County Code at Law number 2 to your client? Now, Mr. LeBlanc, I'm getting ready to go over these documents with you, or this document with you. And the document states Standard Bond Conditions in County Code at Law number 2. Following return of criminal information in County Code at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol when the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And let's see, condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply in this case. However, condition number 5 on the next page does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
And condition number 7 states the defendant shall wear a global positioning monitoring system device at the defendant's expense, with written verifications being submitted to the court within 3 days. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, our court coordinator have a list of places where you can get your GPS, and you can get that information. Once you get it within 3 days, get it to your attorney, and your attorney could send it to us by either email or fax, or you can present it in court. Okay, so your case is being reset along with your felony case. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go, and you have a blessed day.
Who do I talk to about a work experience?
The same person. Okay. Did you get those from Jennifer? Okay, let's see. You're talking to prosecutors about those?
Yes.
Okay, we'll call you back. We'll just put it on hold.
Yes, sir.
Treasurer Harris?
Yes. Can I get a work experience now?
You can go to the reception and have to be
You can tell them what the receptionist is. Okay, this is cause number 25 CCCR 2190. Case is style. The state of Texas versus Treasurer Harris. Ms. Harris, is that your full name? Okay, Ms. Harris, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Harris, you may put your hand down. How are you doing, Ms. Harris? You doing good? That's good. Now, Ms. Harris, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that cited defendant? And are these your initials on the line that states you'd like to apply for a court-appointed attorney? I have another document that is titled Jefferson County Affidavit of Indigence. And do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature? Ms. Harris, before you signed and initialed all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Ms. Harris, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Now, before she gives you that information, the bailiff is going to give you some bond conditions. Document that she just handed to you is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title? And it states, following the return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or orders subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Now, condition number 3 states the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 Texas Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition? And condition number 7 alleges that states that the defendant shall wear a global positioning monitoring system device at defendant's expense, with written verification being submitted to the court within 3 days. Do you understand that condition? Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested, placed in Jefferson County Jail. Our court coordinator have locations where you can get the GPS. Stand in front of the court coordinator and wait for your name to be called. Once your name is called, you're free to go and you have a blessed day. Brett Austin Stanley. Okay, Mr. Stanley, your full name is Brett Austin Stanley?
Yes.
Mr. Stanley, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Stanley, you may put your hand down. How are you doing, Mr. Stanley?
Good.
I'm doing fine. Thanks for asking. Mr. Stanley, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes.
Now, Mr. Stanley, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Stanley, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Nicholas Jeter. Attorney Jeter will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information, you'll be free to go and you have a blessed day. Please have a seat in the chair on the wall.
Thank you.
Kevin Hernandez.
Place your hand over there. Come up.
Mr. Hernandez. Let's see. Okay, now, Mr. Hernandez, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes.
Now, Mr. Hernandez, did I swear you in? Okay, would you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may put your hand down. Now, you acknowledge that this is your signature on the line that's titled Defendant, right?
Correct.
And these are your initials on the line that state you'd like to apply for a court-appointed attorney.
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes.
Mr. Hernandez, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Now, Mr. Hernandez, I was looking at your affidavit. Miss Mosley. Did you hand this document back to him? Let me do this and get off the YouTube. Okay, Mr. Hernandez. Um. Is everything in both of these documents, that is the judge's explanation of rights to defendants without attorney and Jefferson County affidavit of indigence? Everything in these documents is true and correct?
Yeah.
Okay. Mr. Hernandez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. Attorney that will be appointed to represent you in this case is Attorney Jack Lawrence. Attorney Lawrence will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go on your blessed day. Please have a seat in that first chair on the wall.
Is there?
You're welcome. We'll be able to get the Miss Jennifer. This is clause number 25 CCCR 2204. Case of style of the state of Texas versus Oscar Antonio Medrano. And Mr. Medrano speaks Spanish. He speaks a little English. We have our interpreter, Ms. Jennifer Raji, who is present. Mr. Raji, how are you doing? Ms. Raji, I'm doing fine. Would you please raise your right hand? Do you swear to interpret Spanish to English and English to Spanish to help you out?
Yes.
Okay, you may put your hand down. Ask Mr. Medrano if his full name is Oscar Antonio Medrano.
Yes.
Okay. Ask him to raise his right hand. Okay. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
Okay. Tell him he can put his hand down. I guess, como está?
Being mistaken.
Okay.
You say good and you?
I'm doing fine. Now, Mr. Madreno, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Ask him if he recognized this document.
Entonces ese documento que firmaste, no firmes the sign the bottom, Judge.
Oh. There's a pen right there.
What is the headline for you don't put it?
Yeah, Attorney, my name is Jack Lawrence. This is your next court date. You should be contacting me within 20 hours. Every number you can. However, if you have any questions before the court date, is that open?
Okay. Now, Mr. Madreno, is this your signature on the line that's titled defendant?
Yes, eso fue my.
Sí.
Yes.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Y pues eso es diciendo que quieres aplicar para una.
Sí.
Yes.
Also have another document that's titled Affidavit of Injuries. Do you recognize this document?
Yes, please.
On page 2 of this same document, excuse me, page 3 of this. Man, they got it, it's out of order. 2 is 3 and 3 is 2. Okay, on page 2 of this document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, eso fue my. Yes, Judge.
Okay. Now, before you signed and initialed these documents, did Mr. Raji, I think as well as is that your wife?
Is eso was good?
Sí.
Yes, Judge.
Go over, and she speaks Spanish and English too, right?
I did.
Okay.
Yes.
Okay. Now, did Mr. Raji go over these documents with you?
Pues primero que usted, pero oficialmente que maneja de
Okay. He said, yes, Judge, they just told him to make sure that he signed the top portion of the paper.
Okay. Now, did you understand everything in these documents before you signed it?
Entendí todo en el documento antes de firmar.
Estoy entendiendo que aplique para un abogado. Sí, lo.
Yes, Judge.
And is everything in these documents true and correct to the best of your knowledge?
Pues es de verdad. Yes, Judge.
Okay. Mr. Madreno, I read your answers. Based on your answers, meet the eligibility requirements for our court-appointed attorney and the attorney that will be appointed to represent you. In this case, is Attorney Charles Rojas. He speaks Spanish and English. And Mr. Rojas is going to be given information to contact you, and you'll be given information to contact him. Okay. You're gonna stand in front of the court coordinator and follow directions. Okay, you'll be free to go, and you have a blessed day.
Gracias, igual.
Thank
He
you.
said, thank you, the same to you.
Okay. Oscar Vela Yanez. Mr. Excuse me, it's Omar Vela Yanez. And Mr. Yanez, is that your full name?
Yeah.
Now, Mr. Yanez, you speak English, but you also speak Spanish?
Just a little. I need.
You speak a little English as well? Okay. And we have our interpreter.
Okay. Ahí va a estar la cita, ¿ok? Y nomás sobre eso hacemos el ¿ok?
Está, muchas gracias.
Okay. Now, Mr. Avila Yanez, we have Miss Jennifer Raji. She's already been sworn in. Mr. Raji asks Mr. Avila Yanez if his full name is Omar Avila Yanez.
Y su nombre
Tengo un nombre en medio que se llama Bernardo.
He said he has a middle name that's Bernard,
Bernardo? Okay, now, Mr. Avellanes, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, yes,
Okay, you may put your hand down. ¿Cómo está?
bien, good.
Good? All right. Now, Mr. Avellanes, I have before me a document that cited judge's explanation of defendant's rights without attorney. Do you recognize this document?
Yes, yes,
Yes, Judge.
Is this your signature on the line that cited defendant?
yes,
Yes.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
yes,
Yes, Judge.
Also have another document that is titled affidavit of indigence. Do you recognize this document?
yes,
Yes, Judge.
And on page 2 of this document, there's a signature above the line that's titled defendant's signature. Is this your signature?
mhm,
Yes, Judge.
Now, before you sign and initial these documents, did someone go over these documents with you in Spanish?
yes,
Yes, Judge.
On what? This guy case? Oh, he sure is. She sure is. Okay, Marva Provo. What is he doing on the docket?
The jail to be bonded out and just.
He probably didn't show up for his arraignment. Or something for him that, unless no Marva got appointed when he was employed at the jail.
September 26th, yeah.
Okay, he already has an attorney. It's Marva Provo.
Okay.
So we don't need these documents.
You're gonna leave it with her?
Yeah, we don't need these. He's, yeah, I don't know why let's not get straight. You're gonna get your reset from our coordinator. Once you get your reset, you're free to go and you have a blessed day.
Dice que tienes un abogado, antes de salir de la cárcel, y me van a dar un universito, y que dice que regresar en ese mismo sitio con su vida. ¿Ok? Que tenga un día, dice.
Okay, so I'll just do what we said, but more.
Yeah. Is that
I'm feeling that my cousin, uncle, something, what, he has an attorney. So, whatever, we can't change the address in the system. You know, when we're available.
Daniel Ballou? Mr. Ballou.
Hello.
Let's see. Okay. This is cause number 25 CCCR 2514. Case of style of state of Texas versus Daniel L. Ballou. Mr. Ballou, is that your full name?
Yes, sir.
Okay, Mr. Ballou, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, how are you doing, Mr. Ballou?
All right, and you?
I'm doing fine, thanks for asking. Now, before we go any further, Mr. Ballou, I think I know you and used to work for Jefferson County at the courthouse.
Yes, sir. You know my aunt Sylvia Moore. You also, you know my aunt Sylvia Moore.
Sylvia Moore.
Yes, sir.
Okay, I'm glad you brought that up. because, in state, I didn't know she was your aunt until I saw her appear in the door on yesterday. Actually, on today. Actually, on yesterday, when I was doing my walk in the morning, I ran into Miss Moore. And Miss Moore informed me that she had a nephew that was coming before the court today. I informed her that I couldn't talk to her about the case.
Right.
And she didn't talk to me about the case, but I didn't put two and two together until she appeared in here this morning. She appeared in the door. Miss Mosby, is that correct?
Yeah.
Okay. And so you are her nephew.
Yes, sir.
Now, state, if you think there's an appearance of impropriety or a conflict of interest, the court will recuse itself from this case.
Absolutely not, Your Honor. The state has all the confidence within this honorable court to be fair and impartial, but I must disclose, I know Ms. Moore as well, Judge.
Oh, okay.
And I do not see how justice cannot be done within this case, given our relationship with Ms. Moore.
Okay, and just for the record, I did not go into any discussion in terms of this case, and no promises or anything of that nature was made
Your Honor, we would.
as
Yes,
well.
sir. Yes,
Okay.
sir.
Now, now you have to understand, Mr. Baloo, the court is governed by a code of judicial conduct.
Right.
And that means we have ethical ethical rules that we must abide by. And this court certainly will abide by those rules. And so we just had to put that on the record because the court is obligated to make what is called a disclosure to the state.
Right.
Okay. Now, Mr. Baloo, did I swear you in?
Yes, sir.
Okay, I just want to make sure. Now, Mr. Baloo, I have before me two documents.
Yes, sir.
First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
Defendant?
sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
And I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
Now, on page 2 of this document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Mr. Baloo, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Baloo, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Todd LeBlanc. Now, Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go, and you have a blessed day.
You too.
And nice seeing you. Just
Thank
have a seat in that first chair.
Yes, sir.
You're welcome. Do we? Oh, yeah. Oh, I thought you was talking about the Okay. Jefferson County Court at Law is back in session. The court is in session in two cases. Cause numbers 25 CCCR 1330 and cause number M321225. Both cases are filed in the state of Texas versus Russell Thomas Bean. Mr. Bean, is that your full name?
Yes, sir. Yes, sir.
Mr. Bean, would you please raise your right hand? Mr. Bean, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Bean, you may put your hand down. How are you doing, Mr. Bean?
Been better.
Okay, I'm sure it's been worse too.
Well,
Yeah. Now, Mr. Bean, you're represented in your cases by your attorney, Attorney Giles Cole. And Mr. Cole, how are you doing?
Great judge.
And Mr. Cole, do you waive a record in Mr. Bean's cases?
Yes, I do, yes.
And the state is represented in this case by Attorney Kenise Williams. Mr. Williams, how are you doing?
I'm doing well, thank you, Your Honor. And your staff?
They doing fine.
Good day, Mr. Bean.
All right, now, Mr. Bean, I have before me a document that is titled Motion to Revoke Probation. In this motion that was filed by the Jefferson County Attorney's Office, it alleges that you, Russell Thomas Bean, on February 26th of 2023, in County Court at Law number 2, that you were found guilty for the Class B misdemeanor offense of driving while intoxicated. Your punishment was assessed at 180 days confinement in the Jefferson County Jail and a fine of $500. The confinement was probated for a period of 1 year. In this motion, there are 2 allegations. State, are you proceeding on both allegations?
No, just the first allegation, Your Honor. We abandoned the second.
Okay, Mr. Bean, the state is abandoning the second allegation, therefore they will only be proceeding on the first allegation. The first allegation alleges that you, Russell Thomas Bean, failed to pay court assessed fees as ordered by the court, and as of January 11 of 2023, you were $1,732 in arrears in violation of condition 8 of your probation order. Is that true or not true?
True.
Now, are you pleading true to this allegation freely and voluntarily?
yes, sir.
And are you pleading true because it is true?
Yes, sir.
Now, Mr. Bean, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Bean, there are a set of initials on the line that is checked MTRP, which means motion to revoke probation, true to allegation 1. Are these your initials?
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Allegation number 2, not allegation, but the second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Sure.
Now, Mr. Bean, before you signed and initialed all of these documents that I showed you, did your attorney go over these documents with you?
Sure.
Did you understand everything that your attorney went over? Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Mr. Bean, are you a citizen of the United States?
Yes, Your Honor.
State like to offer state's exhibit number one.
So tendered, Your Honor.
Any objections? No objection. State's exhibit number one will be admitted. And Mr. Cole, you've advised and counseled Mr. Bean. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Bean, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided fully effective and competent legal representation?
Yes, Your Honor.
Okay. Now, Mr. Bean, I will accept your plea of truth to allegation number one. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to revoke your probation, and your probation is hereby revoked. State, do we have a plea bargain agreement?
We do, Your Honor.
And what's the agreement?
The essential terms are as follows. Mr. Bean, Your Honor, in consideration of his plea, it would be 90 days, county jail judge. He's already served 69 days, so that should be credit for time served, time actually served, and all fees should be taxed and retired. And for further consideration, the matter will be disposed of M321225 by way of section article, 12.45 of the Code of
Oh.
Criminal Procedure.
Actually, I think that's the
That's
the wrong cause number. Because this cause
You know,
number
it's
is
cor-
M321225.
And that's what's associated with the case. It would be 25 CCCR 1330, Judge.
Right.
That case will be disposed of and dismissed by that one.
Okay, now let me do this here. 25 CCCR 13.
Correct, Mr. Cole? Yes.
Oh.
Mr. Bean, y'all understand?
That'll be a 1245.
Yes, sir.
Section 1245 dismissal.
I haven't seen you watch, so it's all good.
Now, let me do this. Now, the state is offering that now,
The intentions are, Judge, that he should be getting out.
problem is when the jail look at that he has 21 more days, they may look at it as he has 21 more days to serve. And of course, they can give him credit, but we don't know what kind of credit, if they're gonna give him good time credit or not. So if you're intending on him getting out today, you could do 69 days in jail, credit for 69 days, so you would know it'll be time served. Because
I kind of like rounded numbers, Judge, but
okay,
no. It's
Now, state,
Credit for time served, time actually served.
okay, now, state, uh, you've changed your offer in this case, and the state, what is the offer?
Oh, it's 69 days, Judge.
Okay, 69 days, credit for 69 days, and you'll be dismissing clause number 25 CCCR 1330. Pursuant to Article 12.145 of the Texas Code of Criminal Procedure. Is
Yes,
that
sir.
correct?
That's correct.
Now, Mr. Bean, the state is offering that you serve 69 days in the Jefferson County Jail. You will not be required to serve any more time in the Jefferson County Jail because you've already served 69 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. And as part of this plea bargain, clause number 25 CCCR 1330, the companion case, will be dismissed pursuant to Article 1245 of the Texas Code of Criminal Procedure. Mr. Bean, do you understand the state's offer?
Yes, Your Honor.
And do you think that the state's offer in this case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Okay, Mr. Bean, I'll follow plea bargaining agreement that you have entered into with the state. Now, Mr. Bean, if you do not have anything else holding you in jail, you should be getting out of jail today. Now, Mr. Bean, just have a seat in the jury box. And then when your name is called, you're gonna follow the directions of the bailiff. Once you're finished
sir.
following the directions of the bailiff, you're free to go. You have a blessed day. Okay, thank you. And Mr. Cole, you're free to go. I think that, okay, your other case, Williams, was that reset? What, did we find out anything on Williams? Andre Williams?
He was reset.
Okay. Okay, Mr. Cole, you're free to go.
All right, sir.
You have a blessed day.
Same. All right. See you later, Mr. Segura.
Okay.
Segura.
This will conclude the calling of the arraignment docket on today's date, November 18, 2025, in County Court at Law number 2 of Jefferson County, Texas, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused.
Thank you, Judge. Have a wonderful day.
All right, same to y'all. Okay, this will conclude the calling in the docket. Everyone, please have a blessed day.